Hello, everyone, and welcome to this presentation on environmental due diligence and fee to trust transactions. My name is Jennifer Casler. I am a geologist and a senior associate with Hart Krauser. We're a division of Haley and Aldrich, and we have offices all over the country, including Southwest, Southeast, Northeast, Pacific Northwest. I sit in the Pacific Northwest office in Portland, and I'm very happy to be presenting to you today. I had the honor and privilege to present 2 years ago at the National Tribal Land Association's Land Staff Conference in Minnesota, and I'm happy to have accepted the offer to speak on this very topic again. So let's get started. I want to fill you in on a little bit about what I'm going to be talking about. The overview of this particular presentation is I'll be talking about environmental due diligence in the BIA fee to trust process, of course, and I'll go into some environmental due diligence basics. I'll talk a little bit about what environmental due diligence is. Then we'll have some fun time. We'll do a visual quiz where I'll show you some photographs and you can think about what might be an environmental concern, what might not be. Then I'll go into some real world tools that you can use and scale your approach in evaluating properties before you take them into a trust application situation that you can scale depending on your budget and whether or not you have the staff that can do some of this work. And then finally, I'll talk a little bit about going beyond a fee to trust application for your property and talk a little bit about using ArcGIS and other programs to catalog environmental conditions on properties that you may already own, that you might want to consider requesting or going after an EPA brownfield grant application. There's a lot of great brownfield opportunities that a lot of tribes have already taken advantage of through the EPA's Tribal Brownfield Grant Program that I'd like to talk about. So let's get started. We're talking about environmental due diligence in the BIA fee to trust process. Now, the fee to trust requirements for specifically related to environmental conditions of property are in the BIA fee to trust handbook. And in that handbook, you can actually Google it if you don't already have it. It's titled The Acquisition of Title Land Held in Fee or Restricted Fee Status. It's the handbook that your BIA realtor or realty officer would be using. The actual part of the document where environmental assessments and environmental due diligence comes in is step 7, which is, it references the Department of Interior's DM Part 602, Land Acquisition, Exchange, and Disposal, Chapter 2, Real Property Pre-Acquisition Environmental Site Assessments. And in that step, and under that Chapter 2, there is a reference to using the ASTM standard for environmental due diligence, or the Phase 1 environmental site assessment process. So this just gives you a little bit of an idea of where the environmental due diligence piece comes into your overall application that you put together to get your properties into trust. It also works, of course, on fee-owned property too that you're looking to purchase. There are definitely some similarities in the BIA's process and the ASTM requirements for Phase 1 ESA. Again, the BIA requires that Phase 1s be completed in accordance with the ASTM standards. And the Phase 1 ESA really is compiled of some basic components. And that is an environmental professional, someone like me, would come out to the property and conduct a site reconnaissance and review the property to look for evidence of environmental conditions. We would conduct interviews with people that are familiar with the property to further evaluate what may have occurred at that property. Then we would conduct some historical research. We would look at historical aerial photographs. Maybe we might go to some local tribal records. Tribal staff may have information. And then we would conduct an environmental records review, and that would be looking at tribal land use records, regulatory cleanup records from the state and federal agencies. And then in addition to that, we would also ask that the tribe or would be the user of the document or the report would provide information related to purchase price, excuse me, purchase price, activity and use limitations, environmental liens, and so forth. There are some services that are not included in the environmental due diligence process through the Phase 1 ESA, but they are still things that the tribe would need to consider when moving through that fee to trust application. And those are things like regulated building materials, indoor air quality issues, wetlands, things like that are not part of an ASTM standard, but they are things that the BIA might be looking for when they're looking at property through the fee to trust application. The ASTM standards that are typically applicable for tribal lands are the 152713. That is the gold standard for conducting environmental site assessments, and that is on all sorts of properties. And then for larger properties like forest land or rural areas, of which tribes have a lot, would be the ASTM E2247-16. That's another process that ASTM basically has pulled together a step-by-step process for evaluating large swaths of land. And those two standards would be very applicable and useful when looking at an environmental condition of a property and preparing that property to go through that fee to trust process. One thing that's important to keep in mind is that the Phase 1 ESA is, the document itself is good for a year, but after 6 months, you have to conduct a new site reconnaissance, conduct additional environmental record reviews, and more interviews. So just keep that in mind, because that's going to be important as we move along in the conversation. One of the interesting elements of the Department of Interior's BIA policy is found in Part 602 of Chapter 2. And basically it states that the Bureau shall ascertain the nature and extent of potential liability from hazardous substances. It has to, the BIA has to also weigh the benefits of bringing that land into trust versus the total cost of potential cleanup of that property. And then the BIA also has to consider whether congressionally mandated acquisitions of property, if it's contaminated, they need to understand what the cost would be for cleanup. And so really the BIA its intention is to eliminate as much as possible environmental liability associated with taking a property into trust on behalf of the tribe. So the BIA timing and fee to trust applications is interesting because it can take it's a process. It takes a long time to get through that application review process, and they require a lot of elements. And if you look on this slide, you'll see that step number 7, after there's a written request come in or an application, there's a site visit, there's a certificate of inspection, some initial opinions. Then they get to the environmental compliance review piece, which is step 7. And it's only this, the 7th step out of 16 total steps in the review process. And as I mentioned before, the shelf life of and I'm going back to this because I want to show this to you, the shelf life of a Phase 1 ESA, which is your main environmental due diligence product, is only valid for a year. Provided that after 6 months, you redo the site visit, the environmental records reviews, and the interviews. And so if you get stuck in this process for longer than 6 months after step 7 is completed, then you're going to potentially have to go back and revalidate that Phase 1 ESA report, which means you'll have to go back and update some of those elements. Now, some BIA realty officers, in fact, many of them, will wait until they get further along in the process before they request this environmental due diligence document, so that tribal staff do not have to go back and redo a Phase 1. But that's just something to keep in mind regarding timing of these applications. So in comparing the ASTM standard, which stands for the American Society for Testing of Materials, that's that phase 1 standard 15 E1527, comparing that standard with what the BIA does in terms of liability and timing, the standard itself is really intended to reduce liability when you either purchase a property, or in this case for tribes bringing a property into trust. It's not really intending to eliminate. Most of the time you cannot eliminate completely environmental liability, but with the BIA, there is a directive to try to eliminate that as much as possible through the phase 1. And then if anything is identified in the phase 1 ESA as needing to be addressed, then BIA is going to want the tribe to address that before they take it into trust. Then, of course, there's the issue of timing. Again, the ASTM standard is the report, the phase 1 ESA report is good for a year, provided that you do a 6-month update. And just be aware that because the BIA fee to trust process is phased, you want to make sure that you can get that phase 1 ESA within that last 6-month review period before the application is approved by BIA. So managing the environmental due diligence in the fee to trust process is really meant to reduce liability, and you want to make it easy for your BIA realty officer to say yes. You want to make it easy for the application to be approved. You don't want environmental issues on a property to be the tripping point for your application. So that's really the impetus of this presentation, is to really help you as tribal land staff identify those environmental conditions on your property if you have them, and get those addressed before you go through the application process. Again, timing of the phase 1 ESA is going to be potentially an issue, something to be aware of. And again, the shelf life it's valid for a year, provided that after 6 months you update a few things. So let's talk about the basics of environmental due diligence. And I always like to say CREX, HREX, and REX, oh my. Well, what do those acronyms mean? You know, when you're performing environmental due diligence, there are things that an environmental professional will need to do in order to comply. In order for the tribe to comply with the ASTM standard, it has to be done by an environmental professional. However, excuse me, tribal land staff members can do a lot of things on a property before they even hire an environmental professional. What is environmental due diligence? It's simply an evaluation of the environmental condition of a property that's generally completed prior to purchase or sale of a property. And in the case of a fee to trust process, it can be conducted on a property prior to the fee to trust application, before you request that property be brought into trust. Why is it important? Well, in general, performing environmental due diligence satisfies, if you're a property purchaser, it can really satisfy one of the 3 defenses under the federal CERCLA program, and that's the Comprehensive Environmental Reclamation and Liability Act of 1980. You can either, it can satisfy defense as an innocent landowner, which basically means you didn't know or had no reason to know that you had contamination on your property or environmental concerns on your property before you purchased it. You can be a bona fide prospective purchaser and use that defense, and that basically means if you knowingly purchased the property that maybe had some environmental contamination issues on it, but you worked with a regulator to address those before purchasing. Or you have a defense that you're a contiguous property owner, which means just that. You've got an adjoining property that may have had some contamination that's leaking onto your property, maybe through the groundwater or through spills on the surface. You can qualify as a contiguous property owner, all under this CERCLA, this federal CERCLA defense. So that's why it's so important to do environmental due diligence. Hidden environmental liabilities can be expensive. So performing a proper environmental due diligence review of your property, really for any property that the tribe is going to acquire, even if it's in fee, you're going to want to take a look at this before you purchase it. And then obviously environmental liabilities can hold up a transaction. There is a history here about why we do environmental due diligence and really what precipitated all of this. And most people know about Love Canal. It's a very interesting story. It's kind of a crazy story. If you haven't heard of it, you can look it up online. But in Love Canal, it was in New York. There was an open dump right in the middle of a neighborhood, and various industries would dump their chemicals here. A company would take their drums, and it was basically an open dumping ground. There was a lot of illness and sickness in the neighborhood, and that really is what precipitated Congress to pass the 1980 far-reaching CERCLA law. And what it did, it basically made property owners liable for releases of hazardous substances, hazardous waste, and it established a fund for properties that may have been abandoned because cleanup can be super expensive. So it established a fund that the federal government could use to clean up the property if that property became abandoned and became an orphan site. At that time, there was really no definition of what kind of a defense you could have against this far-reaching CERCLA liability. There was no way for a property owner to defend themselves against the law or any potential innocent property purchasers. So in 1986, they amended the CERCLA law, and it was called SARA, the Superfund Amendment and Reauthorization Acts. And they actually added the innocent purchaser defense. But they didn't have defined what an appropriate level of inquiry into the environmental history of a property was, the environmental contaminant history. And in 2002, they had the Brownfield Amendments, which added these two additional property defenses, which is your bona fide prospective property owner or property purchaser defense, and then the contiguous property owner defense. And it wasn't until 2005 here that they finally decided to define what an appropriate level of inquiry was in the property. That's where they established basically a definition of what an appropriate level of inquiry would be into a property, and it established all three of those CERCLA liability defenses, and that was really important. And it's important because the CERCLA law was not just for property owners, but for anybody who had a link to that, anybody who dumped there, anybody who moved waste from Love Canal or who dumped there. It wasn't just the company that owned the property. And a good case in point was the Times Beach, Missouri CERCLA issue, and it was actually a really big deal. This was a company town from a newspaper. I believe it was in St. Louis, Missouri. It was a company town. It was a respite, I guess you could call that, for summer use. And it was a town that did not have paved roads anywhere. And up the road from this town was a company, an industrial facility that would bring in raw materials and would extract chemicals for use in the beauty products industry, believe it or not. And then the waste materials would be basically sent to underground storage tanks, would be stored in underground storage tanks in sort of this oily mixture. And then they would hire another company to come and pump that material out and cart it off to a hazardous waste facility. Well, this one company they hired out a company to do this. They in turn turned around and hired a small mom and pop organization facility to come and pump out the tanks for them. And then what this company would do was they would spread this oily mixture on all these roads to keep the dust down. Well, it turns out that the chemicals that were coming out of those tanks that were being stored by the facility was heavily contaminated with PCBs and dioxins. And it wasn't until there were a series of horses that died and young riders in the horse arenas that died from and got very sick from what happened was they were basically putting down oil to keep the dust down from the dust that was being inside the horse arenas. So when they discovered this, they found out what had happened, and of course everybody who'd been in contact with disposal of this material from the industry that was extracting the material and using it, to all of the handlers of the material, were subject to this CERCLA law. So that's why it was such a far-reaching congressional act in 1980. So that's what precipitated a lot of this. During that time, however, because the EPA and Congress didn't really have any information or couldn't provide any information in the marketplace about what would constitute an appropriate level of inquiry, the commercial industry, bankers, lawyers, people that were working in buying and selling property decided to come up with their own standard for what it would mean to conduct an appropriate level of inquiry into the environmental condition of a property. So they got together with ASTM, which is the American Society for Testing and Materials, and they came up with a standard. And that standard was the 1527 standard. It was they prepared it. The first standard came out in 1993. Then every 5 years after that, they would update the standard. And in 2005, when the EPA finally decided that they could come up with the definition for appropriate level of inquiry, they worked with ASTM, and now they cross-reference each other. So that standard was updated one more time in 2013 to 1527.13, and it does recognize the all appropriate inquiry rule from the federal government, from EPA. Incidentally, the ASTM standard will be updated again pretty soon. I believe it's at the end of this year. There's not a lot of too many changes on it, but it does go into more depth about what historical research and environmental research you'd have to do on that standard. So the ASTM established some definitions that are important for tribal land staff members to understand and know, especially when you can do some of these things that I'm going to demonstrate that you can do on your own. And that is recognized environmental conditions, historical recognized environmental conditions, and controlled recognized environmental conditions. Essentially, a recognized environmental condition is any condition, any condition of hazardous substances, petroleum products that you can see or not see, or maybe evidence of on a property that indicates there's been a release, or maybe it's under conditions that indicate a release could happen, or maybe a threat of a release. De minimis conditions are not recognized environmental conditions. De minimis conditions would be things like oil, just very light oil staining on concrete, maybe some light oil spilled on directly onto the ground surface, something like that. That's a de minimis condition and would not be considered a recognized environmental condition. Historical recs are simply that. They are a past release of any hazardous substances or petroleum products that used to be a recognized environmental condition, but because that recognized environmental condition has been addressed to the satisfaction of a regulatory agency, maybe the state or federal government, and it meets the criteria that they've set for unrestricted residential use, then it's a historic rec. The kicker here, and this is with the new standard too, the new ASTM standard revision that will be coming out in 2021, I believe, is that the standard that has to be met in order for a condition to be historical recognized environmental condition is that the cleanup that occurred, let's just say a cleanup occurred in 1998, and there were some cleanup standards for chemicals. Those cleanup standards that were used in 1998 would have to also meet the 2021 criteria in order for it to continue to be considered a historical rec. If not, then it would be considered a rec. And then a controlled recognized environmental condition is a condition that still exists on the site, but because it is being managed either as an institutional control or an engineering control, it's not causing human health or the environmental effects. So for instance, an institutional control could be don't drink the groundwater. Maybe you've got some groundwater contamination on the property, but because it has been memorialized in maybe a property deed that says you can't drink the water, that would be considered an institutional control. An engineering control could be something like, yes, we've got some soil contamination, we're not going to dig it up. We're going to put a cap on it, an asphalt cap, and use the area as a parking lot. That would be an example of an engineering control. And those are controlled environmental conditions. So those are the three definitions of RECs, HRECs, and CRECs. So what are these? Well, we're going to have some fun here, and I'm going to present some photographs that show some evidence of what you could potentially look at as a tribal land staff member. You're going out and maybe you want to take a first look at the property before you hire an environmental professional. What are some things that you could look for? Well, let's talk about the built environment first. Let's talk about structures on buildings. A lot of buildings have pipes. Some of the buildings are some of the pipes are conduits for electrical, some of them are water, and in some cases they could be vent pipes. So this photograph here just shows a bend in this pipe that could be associated with a vent for an underground storage tank that could have stored petroleum products, especially if you know a building is heated with heating oil. Another example of an oil pipe is this one here. And in this photograph, you can see, if you take a close look, you can see some oil staining around the contact point between the pipe itself and the outside wall of this building. And it even runs down the side of the brick there. But this is an example of a fill port for a tank that's located inside the building. Sometimes recognized environmental conditions are not as obvious. This is a really good example of past site use. Well, it's really current site use, but they were moving out at the time I took this photograph. Obviously, it's inside of a nursery. You can see water pipes that were used for irrigation, and you've got some overhead pipes. In this particular case, this facility mixed their own chemicals for pesticides, and they would use them in drip pipes down onto the plants that were there. But of course, the ground is covered with gravel, and in this instance, there was a buildup of pesticides in the soil. It was shallow, 12 to 16 inches, I think, but still those were concentrations that were found above cleanup standards for the state. And so that represented a recognized environmental condition. Now, at the time that I did this work, I did not know whether the soils contained pesticides at concentrations greater than cleanup standards. But I still called it out as a recognized environmental condition because it was representative of a potential environmental concern. So it was a recognized environmental condition. Another recognized environmental condition could be the leaching of oils off of creosote-covered railroad ties. In this case, if they weren't stored very long, it could be a de minimis condition. You don't really, in this case, I didn't really know how long they were stored there, but there were enough of them and covered enough area where I called this a recognized environmental condition. Uncontrolled dumping could also be a recognized environmental condition. This photograph here is just it was on a property that was pretty remote. I'm sure a lot of tribes have remote properties where there's uncontrolled dumping. People could drop drums of oils or other farm chemicals. And in this case, it could represent a recognized environmental condition, a REC. And then here's some other examples that I pulled together just to demonstrate, what is a REC? Well, former service stations could be a recognized environmental condition. Either the tanks are still in the ground or they're removed, it doesn't matter. Even if they're removed and there was a site that was cleaned up, it was cleaned up 20 years ago, would that site, that cleanup, still meet today's cleanup standards? Leaking drums, obviously, are a form of a recognized environmental condition. Dry cleaners absolutely could be recognized environmental conditions because of their use of dry cleaning chemicals. And in general, chemical handling on a facility could be a recognized environmental condition. Some other things that may or may not be recognized environmental conditions or RECs could be just general trash that you can find on abandoned properties or remote properties. A lot of times trash just consists of household sundry items, paper, plastic, things like that, that may not be a REC. It may be more of a housekeeping issue. Dry materials storage silos may or may not be RECs. If they stored food grade materials, that's not necessarily a recognized environmental condition. But if they stored pesticides or maybe fertilizer chemicals, that could be. Non-compliant oil storage. You know, the drums in this photograph aren't necessarily, don't look like they've had a release, but certainly storing them unprotected, maybe not in secondary containment, maybe a car could back up, a truck, could represent a REC because it represents a threat of a release, a material threat of a release. Debris piles also could be considered RECs, especially when you've got these totes in the background that often contain farm chemicals or other drums. We've got flashing, all number of things. Medical waste, asbestos, wetlands, mold, and those kinds of issues are not generally called out as recognized environmental conditions in a phase 1 environmental site assessment report, simply because they're not part of the ASTM standard. It doesn't make them any less of a concern to a property owner, or in this case, the BIA, when you're looking at putting your property into trust. They're still going to be addressed, and any environmental professional that's worth their title would bring these types of issues to your attention so that the tribe can address them in some other way. And certainly as tribal land staff, you can go and on a property and look for these potentialities yourselves and sort of, you know, it gives you a heads up on what to expect when it does come time to hire an environmental professional. So I want to talk to you a little bit about some of these tools that you can use on your own to evaluate a property before you pull together the application, the fee to trust application. And it really centers around 3 things that you can do. You can conduct some research. You can go out and you can discover by looking at the property whether or not you've got environmental concerns on the property. And then you can address those environmental concerns even before you hire an environmental professional to do that phase 1 ESA, even before you put that report into your application package. That way you can demonstrate to the BIA that, yeah, there were some issues out here, but they've been buttoned up and they're no longer an issue. And it won't hold up the application process. Some of the internet resources, they're coming out with resources all of the time. Obviously, my first go-to, if I were a tribal land staff member, is to go to your GIS data. The better your GIS data, the better your research will be on potential findings from property, especially aerial views on properties. You can go to Google Earth Pro. You can use their, they have a mechanism on their Google Earth Pro website where you can actually go back several years. I think you go back pretty far to look at changes to the property over time. There are many resources that you can look at online. The EPA has a really good one to look at environmental conditions or hazardous materials issues on properties in the area. So there's a lot of things that you can do online. As far as going out to a property, if you go online and you can Google transaction screen questionnaire, you can come up with a checklist that you can use when you take out into the field with you when you're looking at a property. If you've got drums that are on the property, if you've got septic tanks, you can make sure you can get those buttoned up, get the drums off the property into a secured location, or better yet, if they're containing petroleum products or other materials, get them disposed off at a proper location. proper facility. But there's a lot of things that you can do just by going out to the site to look at it and tidying it up before you hire an environmental professional to do that phase 1 ESA. The property checklist, again, you can Google those online and you can get a checklist that you can use to go out into the field and take a look at the property. If you do find something, if you do find evidence of an underground storage tank or large areas of oil spill, let's just say you've got you know, a barn that you've found some tractors that have been parked on it over time and some pretty significant spills, you can have all that removed, and you can hire that out directly and get those taken care of. Then you can hire the environmental professional to come out and do the phase 1 ESA and make that part of your fee to trust package. And the last part of my presentation, I just want to say a few words about beyond fee to trust property applications. And I want to mention the large volume of grants that are available to tribes specifically for brownfield opportunities, for cleaning up brownfield sites and cataloging properties that you may already have. EPA does have a program that's specifically for tribes, and I encourage all of you, if you haven't looked into this already and you don't have a grant already for brownfields, definitely take a look at it, because these funds are available and they do help tribes clean up blighted properties. One of the first things that you can do is take a look at what you've got already that the tribe already owns in trust. It's already part of your tribal lands. Brownfield properties are basically, the definition here is that it's just a redevelopment or reuse of properties, which are generally complicated because you've got the presence of some hazardous substances or pollution or something. It's underutilized. It could even be just perception that a property is blighted or is contaminated, but it really does equal an opportunity, a potential opportunity there. Brownfields can be abandoned service stations. They can be abandoned dry cleaners. They can be on rural land. They could be machine shops that are no longer being used. It could even be residences that have been abandoned that might have asbestos or lead-based paint issues. There could be a lot of different things on properties that are owned by tribes that would be good candidates for brownfield grant funding. They're underutilized properties, like I said. They could be corner lots. They could be properties that are no longer in use for whatever reason. There's really a full spectrum of properties. The key to it is to catalog what you have, and you can start by ranking these properties. If you do a windshield review, you drive around what you have, and you can identify properties that you might want to consider a brownfield. And you can use any number of ways to score these properties and get a list of your top priorities by thinking about what the community wants. What does your community see as potentially blighted properties or potentially contaminated properties? What are the concerns of your community members? You can conduct a simple survey, or you can just do a focus area. It can be just maybe the area where you have the greatest development, or it could be far and wide, your entire tribal lands. And you don't have to do it as a pending transaction. You can just have this survey done and have it for future brownfields grant funding. The way you can catalog them in different ways, but if you do have access to ArcGIS, this is a great way to do it. You can have your ranking system. Again, it's all community specific about what your tribal members want to see. Maybe it's one particular site that they want and that's their top priority, or maybe it's a focus on economic development or human health or environmental health. It could be any number of things. But this just shows you a more sophisticated approach of identifying all the properties identifying some assessment value, and then identifying whether or not you've already got properties that have been recommended by a state or federal agency for environmental screening. So those are some ways that you can identify and catalog and rank your properties that you might have. Using ArcGIS is a great tool that you can identify properties and number them, and then you can click on them and bring up additional information about each property that helps you decide where you might want to go after brownfield grant funding. Again, how you catalog these sites is completely up to you and your community. What lands are important to your community? Is it the natural resources? Do you have a potential blighted area that's adjacent to a wetland or adjacent to a river? Is there a perception that it's one area is more contaminated than another? Are there a bunch of drums that have been sitting on this property forever and you want to get them moved? Is the property located in an area where you think you could have some serious economic development opportunities? There's so many ways that you could rank these things. It's just a good idea to write them down, get the community's input, and then start a very basic process of ranking your properties. You can also get brownfields grant funding to actually do this kind of work. But sometimes demonstrating to the EPA that you've already been thinking about it, then you have started a basic process of ranking, can go a long way in a grant application. Again, cataloging your sites, it can lay the groundwork for brownfield assessment grants. There's also state community assessment grants. One of the, I think, a great help for many tribes is the Kansas State University's program for tribal brownfields. If you can click on this link, or at least just look up Kansas State University tribal brownfields opportunities, they've got some great resources for tribes. So let's recap what we've talked about today. The bottom line, when you're looking at your fee to trust properties and moving them through the fee to trust process, is you really want to get the BIA to say yes. You don't want environmental conditions on your property, hazardous materials, contamination, that kind of thing, to be a tripping point for you. There's so many other moving pieces in these applications. You don't want environmental issues to be one of them. So the liability is really to reduce or eliminate and recognize environmental conditions before the property goes into the trust application. And again, we talked about how you can do that. You can identify them first, remove those contamination issues if you can. Then you can have the environmental professional perform a phase 1 and get the results of that into the application. Again, you're going to want to conduct the internal timing is important. You know, as you go through the fee to trust process, remember that the environmental considerations are, you know, about in the middle of the time, you know, middle of the fee to trust process. It's step number 7, but there's 16 steps to go through. So work with your BIA realty officer to potentially push back your phase 1 environmental due diligence focus until towards the end of the application, so you don't have to redo that phase 1 ESA. Again, there's a lot of in-house environmental due diligence that land staff can do. You can do some research online. You can go out to look at the property and identify whether you've got some environmental concerns and address those before a phase 1 ESA is conducted and before you move through that fee to trust process. Again, my name is Jennifer Casler, and if you are in need of any questions or if you're needing any assistance, I can help. Certainly there's time for questions about anything that I've presented, and I'm available now to answer any questions that you might have or offer more information. But I'm always willing to walk someone through the process and help you get on your way into some additional resources that you can use even before you hire an environmental professional. So with that, I'll open it up to questions. Thank you very much.